Greetings again, our viewers, and welcome to nWealth Conversation, hosted on nWealth Money TV. We maintain, of course, as we always state, that this is the home of great ideas that lead to generation of wealth, that of course we do believe it is a factor to a better tomorrow. My name is Japheth Otieno, and today I am coming to us with a great conversation, with an understanding that you, as our viewer, in the process of creating your wealth, you have clear objectives as to why you do so. And I know that one of the reasons is to take care of yourself, take care of your family and those around you. Now, the taking care of your family may go beyond your life, and that's why we are concentrating today on the topic of estate planning. So welcome to the show, and let's dive into the discussion. Now, for the purpose of the discussion, of course, as it has been our culture and our norm, we bring to us the experts and the people who are well knowledgeable in the area of conversation. Today, I'm joined by, let me call her the Senior Counsel Legal Mind, our learned friend, Opa Wanyama. She is the Head of Legal and Compliance at nWealth Financial Services, with experience of over 10 years, of course, as a lawyer and an advocate of the High Court. Opa, karibu to the show.
Thank you so much, and thank you for having me.
Thank you. Now, on the topic of estate planning, of course, before we walk into the discussion so widely, maybe just define to us what is estate planning and why do you think it's necessary?
Estate planning is, in very simple terms, is safeguarding your legacy. You have worked so hard, you've worked with nWealth, you've amassed wealth, and now you want to ensure that you safeguard your legacy. So estate planning goes into ensuring that you protect and preserve your legacy and the assets that you've amassed, and eventually transfer these benefits or this estate to your rightful dependents.
Let's come back to Kenya, where we belong, me and you. I think the transfer of wealth from a generation to generation has been experiencing leakages. So from where you see it, and as a legal person, do you think this is majorly affected by the failure to have a proper estate plan?
Yes, to some extent. Why? Because most of us, with an exception of a few of us who managed to go through law school, do not have information of what estate planning is and what it entails. Estate planning, most of us would think that it's just about wills, but there's a broader definition of what estate planning is. It comes in to ensure that you plan your estate to cater for when you're not there, as well as when you're incapacitated. So most of the Kenyan population do not have access to this information, hence why passing of these estates becomes an issue or becomes difficult. Well, some of us who still have this information procrastinate. We decide, I'm not making my will today, I'll make it tomorrow. What if tomorrow never comes? That is the question you and I should be asking ourselves. We procrastinate, we say we'll make it tomorrow. My name is Wanyama. That tells you I'm Kenyan, I'm African. I come from some traditional setting somewhere.
Yes.
Where we believe that making a will, it's a myth, Makiu, that making a will means you will pass on tomorrow. That is not true. Some of us have made wills. We have decided how our estates are supposed to be handled when we're not there, and we are still here. So let's try and ensure that we make wills, create those trusts, have those powers of attorneys, so that we ensure that our estate is well handled when we are not here, when we're incapacitated, and the likes.
Wow. I also did a will and I've not died. I'm still here, so you can rest assured that you will not die after doing the will. So in your explanation, you mentioning that there are broader ways of doing estate planning. Maybe just mention a few vehicles that we may use in order to plan for our estate.
Thank you. I think on that topic, on that question, I'd want to major on three. So we have wills, which is basically the most spoken about estate planning vehicle. where one who has testamentary capacity can make a will. That would mean that you must be 18 years and above. You must be of sound mind. Your will must be witnessed by 2 witnesses who are competent. By competent, I mean for the people, for the beneficiaries or dependents who you've provided for in your will should not be part of the witnesses that you bring forth to witness your will. We also have the power of attorney. A power of attorney is, in very simple terms, is you appointing an agent to act on your behalf in case you're not able to. Maybe one becomes incapacitated and they're not able to execute their day-to-day investment activities. So you can appoint an attorney to handle your estate in such an instance. And it can be a specific power of attorney, specific to handling a specific asset, or it can be a general power of attorney where the attorney handles all your assets. Then there is the trust. This is a legal arrangement where you create a trust, appoint a trustee to handle, and you transfer these assets to that trust. So the trustee will handle your estate within the trust, deciding on how, following your directions, deciding on how this estate is supposed to be handled, if it's supposed to be transferred to your children, at what age and at what point. Yeah, and trusts are it's a very efficient vehicle of handling your estate, considering upon the demise of set law, then these assets need not go through the probate or administration process to be determined in court.
Well, I think in the 3 you've mentioned, the will, the power of attorney, and the trust is a common thing, the dependent.
Yeah.
And in Kenya, I think we have failed to realize who is really a dependent. And maybe you can help us know who is a dependent.
I think at this point, it's needful for me to mention that succession in Kenya is governed or regulated by the Succession Act. That's Cap 160, Laws of Kenya. So under the Succession Act, Section 29, there is a definition of who a dependent is. This section defines a dependent as your spouse and your children, whether or not you maintained them in your life while alive. There was an amendment to this section. Before this, the law provided for wife or wives, former wife or former wives, and children, whether maintained by yourself or not. But there was a change just to provide for a spouse, because there was a feeling that the boy child was being discriminated against, yeah? So that for you as a man, for you to get something from your wife's estate, you had to prove that she maintained you prior to her death. So yeah, that's the current position. As for the parents, grandparents, sisters, brothers, for them to be dependent of your estate, then they have to prove that you maintained them for at least 2 years prior to your demise. Yeah. 2
years prior to demise.
Yeah.
And thank you, our viewers, for staying tuned. I know you've picked a lot of things, and as always, encouraged. We hope that you've picked a lot of notes and you're moving on to act. The beginning point is to have an inventory of what you have as a person. Of course, you know your wife, you know your children. So it's just to have an inventory of what you have and how do you intend to transfer it to the next generation. Thank you very much for staying tuned. Remember always to click the like button, share with many other viewers. If you've not subscribed, click the subscribe button. And until I see you in the next episode, stay blessed and plan accordingly.